rule of lis pendens. The law incorporated in Section 52 of Transfer of Property Act 1882 is based on doctrine of lis pendens. So the term lis pendens comes from the word lis, which means litigation, and pendens, which means pending. This is lis pendens, meaning pending litigation. This doctrine has been expressed in a well-known pendentive principle, pendent lite nihil inventur, which means during the pendency of litigation, nothing new should be introduced. So, under this doctrine, the principle is during the pendency of any suit regarding the title of the property, any new interest should not be created. Thus, the doctrine of lis pendens prohibits the transfer of property pending suit. The basis of doctrine of lis pendens is necessary rather than actual or constructive notice. It may be said that this doctrine is based on notice because a pending suit is regarded as a constructive notice of the fact the disputed title of the property under litigation. Therefore, any person dealing off that property must be bound by the decision of the court. For the administration of justice, it is necessary that while any suit is pending in a court of law regarding the title of the property, the litigant should not be allowed to take decision themselves and transfer the disputed property. So the doctrine of lis pendens is based on necessity and is a matter of public policy because it prevents the parties from disposing of disputed property in such a manner as to interfere court's proceeding. Conditions for application of doctrine of lis pendens. So there should be a suit or proceeding. B. Such suit or proceeding is pending before competent court having jurisdiction to try it. C. Such suit or proceeding is not collusive. D. The suit or proceeding must be such of which the question or immovable property is directly or substantially in issue. E. The suit or proceeding must be pending. F. Then neither party to the suit or proceeding shall transfer or otherwise deal with immovable property which is subject to matter of such suit. G. So as to defeat the right of party provided with the leave or permission of the court, even during dependency of suit property can be transferred, but while granting such permission, the court may impose certain conditions which are to be obeyed by the parties. Generally, in such case, court can the security from such parties to whom such permission is granted. If any transfer is made in violation of this provision, then such transfers are not recognized by law as proceeding de novo, not necessary. The court discretionary powers, the court may give permission or not. Now, the object of this doctrine is to avoid endless litigation, to protect one of the parties to the litigation against the act of order, to avoid abuse of legal process. So, illustration for this is A, who is a landlord, has filed a suit against the tenant B for recovery of possession of the premises. B, knowing that he will lose the case, he is debarred or prevented from creating any third party interest in the property during the pendency of the suit. Suppose B creates the interest in C in respect of the property which is subject matter of suit. Then if suit is decided and decree in favor of A, the decree cannot be executed against C who is in possession of the property now. This will defeat the provision of the law. Exception to the rule of lis pendens, the bona fide purchaser for value without notice. Bona fide purchaser is the purchaser who, in the good faith, after due inquiry from the seller, who has taken proper precaution for value, he has become purchaser for consideration without notice. For example, without knowledge of the defective title of the seller, if he is not a bed of bona fide purchaser for value without notice, then transferee shall not be entitled to any protection wherein he purchased the property at his own risk and peril. So the purpose of doctrine or lease tender is not to effect any just equitable claim. This section protects the right of parties who claim interest in property by filing a suit. The rule of lis pendens is based on the maxim that nothing new should be introduced in the pending litigation. So the application of this rule does not depend upon the transferee who had knowledge of the dependency of the proceeding. According to this rule, during the pendency of litigation, no party to the litigation can transfer the suit property with intention to affect the right of the opposite party. Thank you.